This is Professor Moore. I'm just recording a quick video to show you a couple things that are in audio and in movies about diversity jurisdiction. So the first thing I want to show you is an oral argument that occurred in the Seventh Circuit Court of Appeals on January 12th, 2012. It was a case called Heinen versus Northrop Grumman Corporation. And I don't know what the merits of the case were about, but it got up on appeal in the Federal Appeals Court. In front of one of the judges on the panel was Judge Frank Easterbrook, who was actually one of my law school professors, although I would be shocked if he remembered me. In any event, let me show you what happened to those lawyers when they got in front of Judge Easterbrook.
Ms. Barron.
Good morning. May it please the Court, Susan S. Barron on behalf of the plaintiff, appellant Gregory W. Heinen. This matter, we have plaintiff appellant Gregory W. Heinen, who is a T5 systems engineer, who in fact worked for the defendant.
Before we get into the merits, I have a question about jurisdiction. On the day this suit was removed, of what state was your client a citizen?
Massachusetts.
And what in the record shows that? I bring this up because both sides' briefs say, quite peculiarly, that Heinen was a resident of Massachusetts and therefore a citizen of Massachusetts. And there's no therefore in it. And this is a case in which we know his home state is California. He moved to Illinois to take a job at Grumman without changing the state of his citizenship. He still had a home and a family in California. He apparently moved back to California after his time in Illinois was done. His home was foreclosed on, according to your complaint, 2 years later in California. We now find him in Massachusetts, but there's no indication that he's changed his domicile. We looked at the papers filed in both the state court and the removal papers in the district court, and neither of those papers indicates anything relevant to citizenship. So how do we know his citizenship, his domicile?
Your Honor, when he in fact accepted the employment, it is correct that in fact he started out, family resided in California, he started out in California.
Look, we need to know his domicile as of the day this lawsuit was removed to federal court. That was long after he had left Illinois and gone back to California, now presumably gone to Massachusetts. Normal indicators of domicile are such things as where's your home, where do you vote, where's your driver's license. This record doesn't apparently have any of that information in it. And the reason this concerns me is precisely that this man has long-term ties to California, and Grumman is a citizen of California.
Your Honor, his domicile is Massachusetts. He, in fact, after leaving Illinois, in fact, he went to Massachusetts. The family joined him in Massachusetts. He subsequently was employed in Massachusetts, and he still remains in Massachusetts at the time of filing.
What in the record shows this?
The notice of appeal indicated that, in fact,
the notice of appeal doesn't have anything about subject matter jurisdiction. The removal notice, which is the thing that matters, says that Heinen is a resident of Massachusetts and therefore a citizen. And that's simply a legal error. The Supreme Court has held 3 times that allegations of residence are jurisdictionally defective. The district court should either have compelled the parties to document citizenship or summarily remanded this to state court, because an allegation of residence just doesn't cut it. Now, but I repeat the question. Is there any evidence in the record that shows his home, where he votes, or where he has a driver's license from?
Your Honor, I would have to say I don't believe so. Strictly on the
there's a statute which says that allegations of jurisdiction may be amended upon terms in the Court of Appeals. Perhaps you'll want to do some amending, or perhaps Northrop will want to do some amending. But as things stand, we've got a problem.
Your Honor, I will be doing some amending.
Okay, please continue.
Plaintiff appellant Gregory W. Heinen was a T-Systems 5 engineer, which were...
All right. Not a very pleasant thing to happen to you when you are in federal court, in the Court of Appeals, in front of three very distinguished jurists. So this is an example of what I was saying, is that you can get all the way up on appeal and no one has challenged jurisdiction, and a judge on appeal can bring it up by himself. Now, the other side's attorney, who was sitting there obviously this whole time, failed to get the message from Judge Easterbrook. So let's hear what he has to say.
Mr. Friedman.
Morning, Your Honors. May it please the Court, my name is Ross Friedman. Your Honor, to address your jurisdictional issue, the amended complaint says that plaintiff currently lives in Massachusetts. Several times, actually, the amended complaint repeats itself, but in paragraph 83, he says that he lives in Massachusetts.
Would you please raise your voice? I can't hear you.
Sure. The amended complaint, Your Honor, says that the plaintiff is currently residing in Massachusetts.
And you heard me, I trust, discuss with Ms. Barron the fact that the Supreme Court has held that an allegation of residence is, as a matter of law, insufficient to establish federal jurisdiction. Well, what happened in this case is that you, your client, whether you personally or some other lawyer, filed a notice of removal that alleged residence rather than domicile. What matters under federal law is domicile, not residence. It's just a matter of law. And now, if the district court had been alert to this, this case would have been remanded within minutes, because the notice of removal is defective as a matter of law. Now, it wasn't remanded. It has got here. But endlessly repeating the assertion the plaintiff is a resident of Massachusetts gets absolutely nowhere, because the Supreme Court has held that that allegation doesn't cut it. All right?
Yes.
Now, there is a statute, as I told your colleague, it's 28 U.S.C. 1653, which says that defective allegations of jurisdiction in the pleadings may be amended even in the Court of Appeals. So if you want to keep this case in federal court, you need to amend it to allege domicile. And since you've already heard my concern that the defendant is a citizen of California, the plaintiff obviously has ties to California, we need allegations such as where is his home, where is he registered to vote, where does he have his driver's license from, and so on.
Yes, Your Honor. Moving to the merits, there are...
Okay, so if you think you have it bad in law school, just imagine what my law school was like. So there's an example of how it really matters that you allege and support diversity jurisdiction in the proper way. So here's the opinion that came out after that oral argument. The opinion written by Judge Easterbrook, of course. And he says, jurisdiction should be ascertained before filing suit in federal court, or as here, removing a suit to federal court. Counsel have wasted the court's time and their clients' money by postponing essential inquiries until after the case reached the Court of Appeals. That strategy often leads to a jurisdictional dismissal and the need to start over in state court. Why take that risk? Lawyers have a professional obligation to analyze subject matter jurisdiction before judges need to question the allegations. So this is a very recent real-life example. I have another example of Judge Easterbrook doing the exact same thing a couple years earlier. It was basically the same issue, except I think it was the citizenship of a business entity. Okay, now I just want to tell you about a website that's very valuable. It's called oyas.com. And it is a treasure trove of Supreme Court arguments. So the oral arguments in front of the United States Supreme Court, I don't know how far back they go. They don't go back to the beginning of time, obviously. But the first Supreme Court case that we've read this year, Hertz Corp versus Friend, is located on oyas.com. I don't know that I'm getting the entire screen in there very well, but this is the website, Oyas. I'm sorry, it's not oyas.com, it's oyas.org. This is Hertz Corp v. Friend, which we should have read for today, but we didn't get to it, so we'll discuss it on Wednesday. So you'll see this has all kinds of valuable information. It gives you the facts, it gives you the questions, and then it gives you an audio, not a video, but an audio of the oral argument in the case. So if I click on that, and then I want to expand the player so that it's bigger, it's going to give you the actual transcript as well as a picture of whoever the speaker is. So let me just start out. The speaker is going to be the lawyer for Hertz Corporation, arguing, of course, that there is diversity jurisdiction.
We'll hear argument next in Case 08-1107, the Hertz Corporation versus Friend. Mr. Srinivasan.
Thank you, Mr. Chief Justice, and may it please the Court.
Well, so I just clicked on something that closed that down. But anyway, you get the point. So I just wanted to bring that to your attention. If you want to listen to the oral argument in that, be my guest. It's not required, but it is very interesting sometimes to hear these arguments. Now, on a lighter note, I'm sure you've all seen the movie Legally Blonde. And Legally Blonde, if you recall, has a scene in which Elle starts law school. So it's her first day of law school. And it's a civil procedure class. And they start out with, just as we did, the case of Gordon versus Steele. Okay, I've skipped to the part of the scene where the professor calls on Elle.
I've read pages 1 through 48 and are now well versed in subject matter jurisdiction. Who can tell us about Gordon versus Steele? Let's call on someone from the Hartzer. Elle Woods.
Oh, actually, I wasn't aware that we had an assignment.
Oh. Vivian Kensington, do you think it's acceptable that Ms. Woods is not prepared?
No. I don't.
Would you support my decision to ask her to leave class and to return only when she is prepared?
Absolutely.
Now, Miss Kensington, did diversity jurisdiction exist in this case?
No, it did not.
So Miss Kensington answered the question, did diversity jurisdiction exist in this case? No. So, was she correct? Think about Gordon versus Steele. And I will see you soon. Thanks for watching.